that we aren't together in person. It's a little bit unfair to tie me down to a chair. I'm one of those guys that likes to walk around the room and wave my arms and have a little fun doing these things, but I'll do the best that I can sitting in the chair to talk to you about something that I think anybody that runs and operates a business needs to be tuned into right now, which is to what extent are you running risk of having one of two types of claims made against you, either claims by employees of your business or claims by folks who are there to, in this particular circumstance, to ride on your buses and your motor coaches. And to be blunt about that, how concerned should you be about getting sued? Because that is the thing that, or at least one of the things in this crazy world that we're living in, is at the top of everybody's list right now. So I'm going to talk to you generally about what we call as lawyers premises liability, which really focuses on just a couple of things. I'm going to talk to you generally about what premises liability is, and then I'm going to talk to you a little more specifically about what it means in the context of the crazy world that we're living in now with the advent and the continued progression of COVID-19. So what does premises liability mean, and why should you care about it? And I can tell you that generally speaking, premises liability is the law that basically says that property owners are going to be liable for accidents and injuries that occur on their property. It's a concept that's rooted in negligence law, and that's important for reasons I'm going to explain to you in just a few minutes. Folks typically think about it in the context of individuals who may come onto your property and for whatever reason get injured. We do a lot of work for the Omni hotels and resorts and see a lot of premises liability claims. And the most typical claim that we get is somebody comes into an Omni and slips and falls on a wet floor and will then sue us, claiming that there are things that we should have done to make the premises safer or things that we should have done to warn. That's the context that premises liability claims typically come up in. It includes you, however. It's not just places like the Omni and Food Line and Safeway. It includes everybody that operates any commercial enterprise where they invite people to come onto their property. And it doesn't have to be fixed property. It can most assuredly be not only your buses, but places where people are boarding buses or getting off buses or waiting to queue up to get on motor coach. So it is something that applies to you in all circumstances. And again, the typical types of cases that we see are cases that involve slip and fall in a grocery store, somebody who gets too close to the tiger cage at the zoo. We see a lot of cases that involve swimming pool injuries. In your case, it would most assuredly involve things like loose or broken bus steps, or if a driver were to close a door on a passenger, or there's a problem with a seat, or any other issue that would be specific to the bus. Those are typical cases. Typically, in those cases, there are a line of defenses that are available to us, and things that I usually tell people to think about, and we as lawyers for these companies work really hard to develop, which is, number one, did we as the owner of the premises have notice of whatever the supposedly defective condition is? In any of these type cases, you have to demonstrate, or the person who's making the claim has to demonstrate that the owner of the premises actually knew about a defective condition or should have known about a defective condition. Also, in these cases, we always raise the defense of contributory negligence. And by that, I mean Virginia and a host of other states, not many anymore, but still some other states, typically find that anyone making a claim against you must not have contributed in any meaningful way to the happening of the accident that they are claiming caused them injury. So if a plaintiff, that is a claimant, is in any way negligent, then typically their claim can be barred, or at least you can argue that the claim can be barred. And one of the big things that we argue relative to that is claiming that whatever the supposed defect was open and obvious. For example, anybody that were to be getting onto one of your buses and there was a spill in the vestibule of one of your buses, we almost always would take the position that the person boarding the bus should have seen the spill, should have recognized that it was a potentially dangerous condition, and should have their own volition avoided it. The other defense that we almost always raise in these type of cases are what I call, or what is called, the assumption of the risk defense. And that's important relative to the COVID-19 discussion that we're going to have, because it implicates something that everybody wants to talk about, which are liability waivers. The assumption of risk essentially stands for the proposition that if somebody is fully apprised of the risk that's involved in engaging in a particular activity and decides willingly, voluntarily, and knowingly to engage in activity while being fully advised of the risk, then they cannot recover if they are hurt. Anybody that has ever been bungee jumping or taken a tour while on vacation, or God forbid, decided that they were going to go skydiving, is probably aware of the voluminous legal documents that you're required to read and sign before you engage in any of those activities. Those are typically liability waivers, and those are typically executed, number one, to apprise the participant of whatever the risk is of the activity in which they're preparing to engage, and then to have them knowingly acknowledge the existence of the risk, with the idea being that once they have done so, the person providing the activity can't be found and held otherwise liable. These cases, like all the cases that we handle on the casualty side, are about one thing. They're not about truth. They're not about justice. They're not about anything other than money. And it's about people who are looking for an opportunity to make a claim, with the idea being that they are going to get paid as a result of making some kind of claim in which they say that you did something wrong and that they were injured as a result. So how does a typical case arise? That is, what is the cradle to grave trajectory of one of these type cases? Well, what typically happens is that somebody is going to say that they were injured due to a dangerous condition that existed on the property that was owned by whoever was providing the activity that we otherwise are talking about. That will result in typically the presentation of a claim after the happening of the event, which the individual says that they were injured. And that claim, if left unresolved, usually will morph into a lawsuit that is filed in whatever is the most friendly venue for the person making the claim. Once those lawsuits are filed, then there are four things usually that the claimant has to be able to prove to be able to demonstrate that they are entitled to recovery. And that's a duty, a breach of a duty, that the breach of the duty caused their injury, and that they have sustained some type of monetary damage as a result of the injury. The duty is the easiest part of what it is that a claimant typically has to demonstrate. And in any of these cases that involve premises, and again, those are fixed premises, or in your particular circumstance could be not only your fixed premises, but also the motor coaches that you all operate. The duty is imposed upon us by the law and requires us to make the premises reasonably safe for the people who come onto the premises for purpose of conducting any business activity. And that means, in layman's terms, that you have to exercise ordinary care to make sure that the premises are reasonably safe. You can tell lawyers drew these concepts up because what is reasonably safe is always a question that is going to be decided by a jury, because that can differ from person to person. The steps and the activities that you need to take to make an activity reasonably safe may vary. What somebody listening to this may think is the absolute minimum you should be doing may be something that somebody else hears and thinks that's the absolute maximum I should ever do. And so the net result of that in a lot of these cases is it's ultimately up to a jury to decide whether or not the steps that you took to make some place safe, in fact, were reasonable. Without getting too complicated, if you operate a business or you own premises, it's really not just operating a business. If you own premises, whether a motor coach or any fixed premises where people board or get off the bus or decide that they're going to leave what it is that you're doing, there are three categories of people that you otherwise got to worry about, and each category determines the particular duty that you may owe to them. As a general proposition, the first category of folks to whom you may need to be concerned about is a trespasser. somebody who is either not invited to be on your premises or otherwise has no right to be there. You owe no duty, generally speaking, to a trespasser. There's nothing that you have to do to make your premises particularly safe or anything in terms of ordinary care that you got to exercise relative to them. The second type of category of person that you need to worry about is the group called licensees. And those folks, think about them as social guests. If after hours you invite somebody over for Coca-Cola, or there's somebody who's coming by just to pay you a social visit, then you only have a very minimal duty that's owed to those people. You have to tell them prior to the time they come on your premises, or contemporaneous with them coming on your premises, of any known dangers of which you otherwise are aware. So if your pal comes over after work for a soda and you know that there's a big hole in your front porch of your business, then you are obligated to warn them about that before they come onto the property. And failing to do so would constitute a breach of the duty that you owe to them. The one that you need to be concerned about is the people that you deal with, the people that you're going to carry on the coaches are business invitees, and they are owed the highest standard that's otherwise available in the eyes of the law. That means essentially you need to be conducting reasonable, there's that word again, reasonable inspections to ascertain whether there are any known defects or dangers on the property that you are holding open to them, or any dangers or defects about which you ought to know that could be hidden. And that's where the obligation to conduct an inspection comes in. The big thing that I really want to make sure that we talk about, not just generally speaking in premises liability law, but how does the advent of COVID-19 really impact all of this? And what do you need to think about as business operators relative to the impact of COVID-19? Be mindful again of what your duty is. You've got to maintain your premises in reasonably safe condition. You've got to warn about anything that you know about. And if there are any hidden dangers, you better be conducting some types of reasonable inspections to figure out whether there are things that you ought to know about that you need to be warning your customers of. This junk isn't going anywhere fast. I saw yesterday, probably as many of you did, the president announced the advent of a fast-track therapeutic that he hopes is going to be authorized by the FDA to use to start treating some people. We are still, though, I believe, months, maybe many months away from having a widespread therapeutic that's going to be available to the general population. And God only knows if and when we ever are going to see a truly effective vaccine. The reports relative to that are all over the board. There are some folks, Dr. Fauci and others, who would suggest to you that by the end of this year, maybe the first part of next year, there will be a commercially available vaccine that's available, but we don't expect it, at least according to news reports that I'm seeing, to be widely available for use until sometime in the second or third quarter of 2021. So what we've got in front of us right now is what we as business owners are going to have to deal with. We pulled up just the map for Virginia. The map for North Carolina, South Carolina, and other places doesn't look too dramatically different. The bottom line being the total number of cases continues to go up, the total number of hospitalizations continue to go up, and the total number of deaths continue to go up. The rate at which all of those are increasing varies by locality, obviously, and also varies from state to state. But the takeaway on all of it is it's here, and if we're going to operate our business, we need to be mindful that it's here, and there's some things that we need to understand and do to be in front of it to the greatest extent possible. So what am I seeing as a lawyer relative to these type of claims? Well, I'm seeing two types of things. I'm seeing first the concern that your workplace and having employees in your workplace might subject you to potential workers' compensation claims if somebody in your workplace actually contracts the virus and otherwise gets sick. The other thing I'm seeing are a number of folks who are raising questions about, all right, set my employees aside. I think I'm doing everything that I can for my employees. What are my potential exposures relative to folks in the world who are coming onto my premises for purposes of conducting business? I, as a lot of business owners, had hoped that we were going to see federal legislation that provided widespread immunity for business owners relative to these type of claims. That is legislation which said that assuming you do a certain number of things, you would have immunity from either workers' compensation claims or from third-party liability claims. That hasn't happened. And to be candid with you, without sounding like a cynic, given the political environment that exists in Washington, D.C. right now, I would be surprised if the two sides of the coin could agree that today's Monday, much less agree on whether or not they're going to provide widespread federal liability protections. So as you anticipate these type of claims, I think it's important for you to know what a claimant would look to establish relative to you so that you can then get yourself positioned to try to insulate, or no pun intended, inoculate yourself to the greatest extent possible. So mindful of what I told you earlier, that to prevail on one of these type claims, a claimant has to establish that there's a duty, that there's a breach of duty, that the breach of duty caused the injury, and that as a result of the injury, they have been damaged, i.e. they have suffered monetary loss. How are they going to do that relative to a COVID claim? How are they going to establish first that there's a duty? That's easy here, because here there are a multitude of federal and state agencies that are articulating duties all over the place for people that otherwise are operating businesses. Just look at what the CDC says, or what the CDC has said today, because that might be different than what the CDC said last week or last month. But the CDC has articulated a multi-step analysis that you need to be following relative to the operating of any business. The things that you need to do, what they call reduce transmission, maintain healthy business operations, things to consider and things to discourage. You ought to have somebody, if you're going to operate your business, you ought to have somebody in your business organization who is checking what the CDC says, at least on a weekly basis, to make sure that you're staying abreast of what their articulated CDC guidelines are. And perhaps as importantly, to checking to see what the CDC says, you better have somebody who's making sure that whatever the CDC says is being complied with. Because failure to do that makes it really easy for somebody who were to come on your property and get sick to look back at you and say, well, what were you doing to stay abreast of what the CDC was saying? What were you doing to ensure compliance? Who was charged with doing that? So that's step one that I would suggest that you be aware of, which is that one of the first steps or one of the first duties that are being articulated. There are interim guidelines that have been published by the CDC of things that you ought to be doing, conducting daily health checks, conducting assessments, encourage employees to wear face covering, implementing policies, making sure there's adequate ventilation systems. All those things are found on the link that we otherwise have embedded here. Again, the big takeaway here is make sure you're aware of these things and that somebody is otherwise charged with compliance. But it doesn't just stop there. And again, as we see claimants try to develop these cases, in addition to looking at what the CDC says, they're also looking to see what OSHA articulates, because any workplace, any fixed workplace, and then many of the motor coaches about which you guys are talking about, either going to be subject to compliance with DOT regulations or OSHA regulations. So knowing what OSHA has articulated relative to making workplaces safe for employees is going to be important to you relative to any potential workers' compensation claims. We've picked out the Virginia Department of Health. Each state has its own Department of Health. Whatever they are articulating relative to the virus and steps you need to take relative to the virus are things, again, that you need to be aware of, and things that you need to have somebody appointed to make sure that you are complying with. Be mindful of the fact, again, without the risk of repeating myself, be mindful of the fact these all go to the concept of duty. These will be the type of things that if somebody gets sick, a claimant's going to say, well, you didn't comply with the CDC guidelines, you didn't comply with North Carolina Department of Health guidelines, you didn't comply with OSHA guidelines. Those will be the things that they set up as the first thing that you should have done relative to make the motor coach or the places where they otherwise operate safe. Virginia has issued, first in the nation, as a matter of fact, emergency temporary standard / mandatory guidelines about which employers, and not just employers, but business operators need to be aware. And I would say if you're operating in Virginia and you don't know about these, you need to know about these. Because these things, while they have suggested that they may be the minimum standard to which employers and business operators are going to be held, I would suggest that they are going to be a mandatory standard pursuant to which business operators in the Commonwealth are going to be held. And there's some things in here that sound fairly scary and fairly technical that you need to be thinking about doing. Conducting assessments of the workplace, classifying jobs, either being low risk, high risk, medium risk, low risk, and trying to figure out where your employees and where people that may come onto your premises otherwise fall. Having policies and procedures in place for employees to report if they have been demonstrated any symptoms consistent with the virus, prohibiting folks from coming on, returning to work if they have had symptoms of the virus or actually had the virus itself until they've either been through a symptom-based or a test-based strategy. Making sure there's a system in place for employees to report having symptoms and knowing when you've got to go to the Department of Health or the Department of Labor. Those are just some of the things that otherwise have been articulated that all employers or anyone operating a business had better be aware of and better be tuned into. So what would I tell you that you otherwise need to think about are some things, at least relative to those standards, that you ought to be doing. I can tell you what we do, and we operate a law firm which has some, but not a great deal of contact with the general public. I take everybody's temperature every day when they walk through the door and make sure that they are within an acceptable range before they are allowed onto the premises. I would suggest to you that you think seriously about, prior to letting anybody on one of your buses, that you are taking their temperature. We have a strict mask policy that we otherwise enforce around here. You can't see my associate Cindy, who's with me, but she's sitting here with hers on now. Anybody that comes onto our property has to certify that they don't have any symptoms before they enter the premises. I don't use liability waivers, but I'm suggesting to you that you may want to think about using liability waivers before you put anybody on any of your motor coaches. And I certainly would put up signs and put up things in any fixed premises I had, as well as on my motor coaches, that encourage suitable social distancing. I would, under all circumstances, tell any employees who are reporting any symptoms consistent with the virus to stay home. And if there are ways for you, particularly your support personnel, to work remotely or to telework, if that's an option that's available to you, I'd make sure I had articulated those policies and had as an option the ability for folks to otherwise do that. I would talk, I think this association is great. I think that the ability to communicate with each other is great. I think it's important because you're going to want to know what everybody else is doing. If there are folks that are taking really extraordinary steps, you need to be aware of that and try to figure out whether you want to do the same kind of thing. And I think it's also very critical that you have information circulated where not just for your customers, but also for your employees, that you remind people of the things that we all learned in third grade, which is cover your mouth when you cough or sneeze and wash your hands. Those kind of things, if you are putting up signs and you're putting up posters and you're embracing that, if and when we have a claim that's made against us, those things become very, very helpful. You can go on to the next one. As I said, the recommendations that have been articulated, I would tell you, I think they're mandatory. You're going to see, and I'm as tuned into anybody. I mean, there are people who are militant about not wearing masks and people who were militant about wearing masks. Yeah, there's some video circulating on the internet of people who get in a fight on an airplane because somebody's wearing a mask, somebody's not wearing a mask. It happens at restaurants, and there are lots of people who feel very strongly about it. Whatever your personal beliefs are, I'm telling you, for your business, however, if I'm sitting where you guys are sitting, then under as many circumstances as is humanly possible, if I've got customers that are going to be involved in the riding of my buses or that they're getting on or getting off of my buses at fixed points, I'm making those guys wear masks. The airlines are doing it, and I think it's a good example for everybody else that's in any kind of mass transportation platform to otherwise do. These are the floor. These are the kind of things that I suggest to you are the floor. That is the minimum amount of things that you ought to otherwise do. I also believe that you ought to have some type of enhanced cleaning procedures that are in place, that you probably need to make sure that the buses are cleaned comprehensively, both before trips, after trips. And if there's some way to do simple things during trips, I might even add those as well. I mentioned the state-of-the-art guidelines. As with most things, the larger carriers are going to be doing the most because they have the most disposable income to divert toward safety precautions and safety measures. It is truly one of those deals where, generally speaking, more is better on this, and being aware of what people in the industry are doing is a very smart thing for you to do at this point. I hear often whenever we make these types of presentations, people will say, look, how would anybody ever prove that they caught the virus from being on one of our motor coaches or being exposed here in my office or in places where we otherwise conduct business? And a lot of people who don't deal in the cesspool of slime that I deal with on a daily basis think that may provide them some cover. Don't believe that. The first thing that you're going to do is, if you don't pay attention to the kind of things I'm suggesting to you, is you're going to make it easy for a claimant to establish a breach of a duty. If you aren't following the guidelines, if you're not aware of the guidelines, then all they will simply say is there were guidelines that were articulated out here that you should have known about and you didn't follow, and that constitutes the breach of a duty. And then the folks who believe that, well, they'll never be able to establish that anything happened at our place will find out that they are wrong, because what a claimant will simply do is go out and hire one of these doctors who are for rent, who will provide an opinion about anything if they get paid the right amount of money, who will come in and say, well, I'm looking at Acme Motor Coach Association over here. They didn't follow the Virginia State guidelines or the North Carolina guidelines. They didn't follow what CDC said. They didn't pay attention to what OSHA says. That's the duty. They breached it. And the individual who got sick is going to say, I promise you that they hadn't been anywhere else in the world. They hadn't been to the post office. They hadn't been to Food Line. They hadn't been to anywhere else. All they had done is leave their house, go to your place of business where they got sick. And so they'll find a doctor or an expert who will render an opinion that it's more likely than not that they contracted the illness while on your property. That's how they'll make the case. And it's not me just saying that. That's how they are making the case now against airlines and against the cruise line industry. We're seeing a multitude of cases that are being filed against those industries already, and that's exactly what the experts in those cases are saying to make out their cases. And there's a load of those experts out there right now. And I'm telling you, you should have some more than passing concern about these guys, because they're actually advertising websites where you can go to and you can find these experts who hold themselves out as being prominent names in the field, voices in the field, establishing that various business operations didn't do the things that they should have done to protect the public that they were obligated to serve, and that folks got sick as a result of the breaches of those duties. And the places that you're seeing tons of litigation relative to this already are in nursing homes, hospital administrations, cruise line industry, airline industry, those type of things. If they make out those kind of cases, the damages that are recoverable against you are any type of medical expenses that they have incurred, any wage loss that they've incurred, anything they've paid for medical care, prescription drugs, and of course, the ubiquitous pain and suffering. And we have people dying from this. So being aware that the damages could be substantial is something that I would suggest to you in the strongest terms. So what do? If you understand that's the game, if you understand that's how they will set a case up, they will look to see if you were knowledgeable of the guidelines, whether you followed the guidelines, whether somebody was exposed, whether somebody got sick. What do you do? I would tell you, line of defense number one for you is going to be a liability waiver. And I would encourage you in the strongest terms to make sure you have crafted suitable liability waivers that you can have your customers sign before they get on your motor coaches. In some jurisdictions, those liability waivers will not be 100% bulletproof to get you a get out of jail free card. Virginia is a little quirky with respect to the enforceability of liability waivers. But what a liability waiver will do 100% of the time is provide us with an assumption of the risk defense. If you include language sufficient in the liability waiver to make sure that it is clear that anybody boarding one of your vehicles knew of any potential risk associated with the boarding and the riding of the vehicle, that you warned them about it, they had an opportunity to read the waiver, they had an opportunity to sign the waiver, they were under no duress to do so, they did so of their own free will and volition, then we will in all circumstances at least have the defense that the individual knew before they got on the bus that there was a possibility they could contract disease or virus on the bus. They signed the waiver anyway, got on the bus, and took whatever trip that they wanted to take. In all jurisdictions, that's going to give us the defense of assumption of the risk. And in some jurisdictions, the mere signing of the waiver will bar the claim in and of itself. So that's going to be important. The other defense, obviously, that we raise in any of these cases is what I call the lack of notice defense. You heard me talk about it earlier. You need to make sure that we are continually positioning ourselves relative to all our coaches to say that, and we do not have in service any motor coaches in which we ever had anybody that we know was sick on those coaches. That is, we had no notice of the presence of any disease on any of the inanimate surfaces. Any of those coaches that we're using enhanced cleaning procedures, we're using sanitizers, we're using things to keep the coaches clean. Therefore, we didn't have any notice. Contributory negligence is going to be tough in these cases, but if somebody knowingly comes on the coach and we know that they are sick, then perhaps, but I can't imagine there's ever going to be a circumstance where we're going to let anybody who we know to be sick get on any of our coaches anyway. This is some sample language that you might want to consider including, at least some parts of this and anything that you have your customers sign. It's important that you tailor those to exactly what it is that you're doing, length of trip, how many people are going to be on the trip, how you're going to arrange the seating on the trip, and the amount of time the individual has to read the release, the amount of time the individual has to digest the release. I would say more is better in that circumstance, getting the release to them well in advance of their trip, or at least if they're taking a trip where they show up and they're leaving at 1 o'clock. You know, they have 30 minutes, an hour to look at the release before they otherwise go. Those are all things that help relative to the enforceability of a release document. They're getting used by a lot of people, a lot of places. I don't know if any of you have been to any workout facilities. We represent Gold's Gym. Gold's Gym is using waivers and releases for patrons who come in there. If you've had any dental care or been to a hair salon, a lot of the folks, we represent some of those type of folks as well. We're encouraging them to use them. And some universities, believe it or not, are actually getting away with using them. University of New Hampshire being a notable participant in that kind of program. If you don't do some of the things that we otherwise talking about, this is where you might find yourself sitting. And I can tell you, in 33 years of trying cases all over the country, it is much better to listen to your lawyers and your counselors on the front end to stay out of this situation. Because once you get in this situation, it starts to cost money, and you find yourself in a position where 7, 11, 12, depending on which venue that you otherwise are in, people that you don't know are going to sit in judgment of what you did, applying the very unhelpful Monday morning quarterback scenario to whatever it is that you did. Because it's always easier to look back and say there's something else you could have done or something that you should have done, and to make out a case for why you may be liable for somebody getting sick or dying. The lawsuits are here. They're not coming. They're here. We counted up, and I think this is probably our last count's probably about a week. or so dated. I would expect by now we've seen something like 5,000 lawsuits already filed across the United States. As often happens, a lot of the litigation of this sort starts out west and moves east. If you look, you can see that California is already seeing a bunch of them, New York seeing a bunch of them, Texas and Florida also seeing, and Virginia is starting to see some of these cases, as is North Carolina and South Carolina. The ones that have been hit a lot so far, and the one I would tell you need to keep your eye on, are cruise lines, because they're in the recreational industry. They're in the industry where they haul a lot of people, albeit by boat in their particular circumstance. But hospitals, senior living facilities, airlines, and cruise lines, fitness chains are all being sued. And they're being sued with claims that the people that operate those businesses didn't pay any attention to the guidelines, allowed people to come onto the property. Those people got sick, those people got ill, and some of those people died. And that is what is running the lawsuits. Some states have passed laws that are providing immunity from COVID claims. North Carolina being notable among them for purpose of conversation that we have here today. But it's not absolute. What state's done so far is not absolute. It doesn't bar any regulatory actions, criminal charges, and notably doesn't bar workers' compensation claims. There's no immunity articulated whatsoever in Virginia, South Carolina, some other states that we otherwise service, at least not in this point. As I said, Congress is considering granting widespread federal immunity. I don't think it's going to happen. And for that reason, right now, the lawsuits that have been filed really are picking on the state and federal guidelines that I have otherwise articulated for you. There's an article in Wall Street Journal the other day. For those of you who have not had the experience of dealing with claims and lawsuits, or at least substantial lawsuits, we deal all the time with the bad guys on the other side, the plaintiffs bar, and they are not shy whatsoever in articulating their desire to make this a $100 billion industry. They're going to sue everybody that they can find anytime they find somebody that got sick, where they can reasonably trace it back to some particular workplace, some particular business, or some other place that's experiencing any kind of issue with an outbreak of the virus. Walmart has been sued for it. They had their first wrongful death lawsuit filed against them. I think it's been about a month now, and the claim is just what I have articulated for you, that Walmart knew that there were people who were working there who had symptoms, that Walmart failed to respond and required the employees to keep working, that Walmart didn't clean the store, it didn't enforce social distancing, it didn't inform other employees about other employees who were sick or showing symptoms, didn't provide protective gear, and so they have been sued. They're just one of many that are going to be sued over this. So specifically speaking, what should you do? Let me tell you, the first thing I would do if I were you is I'd look at my insurance policies. I would want to know if my insurance policies are going to protect me in the event that I get a business invitee files a COVID lawsuit against me. Lots of folks, believe it or not, have insurance policies that have virus exclusions in them. So you need to look to see whether or not there's any exclusion in your policy. And I would encourage you in all circumstances to have a pretty vigorous conversation with whoever your broker or agent is to make sure that you, in fact, have coverage. I'd also tell you, if I didn't have coverage, I would think long and hard about continuing to operate with the general public. If you do have coverage for business invitees, then the other thing I would suggest you take a look at is your workers' comp policies. There's a big argument going on right now in a lot of states about whether or not anybody who contracts COVID is going to be allowed to make a workers' compensation claim. I talked to my broker the other day, and there's been something like, I think she told me 1,000 comp claims filed in Virginia now that are COVID related. So far, they've all been turned down. But in Virginia, like in a bunch of places, the legislature is considering whether to make those claims specifically compensable. There's a bill that's actually being considered in the special session right now that would make those claims compensable. So you need to be aware of that, and you need to make sure that whoever writes your comp coverage, that you would have protection for that in the event it became compensable. The second thing I would suggest you do is you need to have somebody who's designated as a workplace coordinator. And when I say workplace coordinator, I mean somebody who, as part of their job while this pandemic continues to rage, is tasked with the responsibility of being generally knowledgeable about the various guidelines that might apply to the operating of your business. And I'm telling you, at minimum, that includes what the CDC articulates, what OSHA articulates, what your state may articulate. And to check, I'm one of those very compulsive guys that has calendar reminders set up for everything, including when I go get a cup of coffee every day. But I would have my coordinator checking at least on a weekly basis. And most of those sites, the CDC site and the OSHA site, as well as the Virginia site, and it's the same way for the other state departments of health, set yourself up to get notices and notifications anytime that there's something that changes relative to the guidelines. And if you're not getting notifications, at least checking once a week to see if there are any changes relative to the guidelines that otherwise have been articulated. And not only knowing what the guidelines are, but making sure that you have somebody who's in charge of policing the guideline. For example, here in my office, my firm administrator is tasked with that. And she gets here early every day and makes sure that we have the appropriate hand sanitizer out, that we've got soap set out, that there are plenty of masks available, that the thermometer is at the front door, we've taken people's temperature, and she will walk around during the course of the day to make sure that folks are wearing their mask and practicing social distancing. So your workplace coordinator is somebody who's not only going to be familiar with what the guidelines are, who's checking what the guidelines are, but who's also going to be responsible for enforcement. And I'm telling you in no uncertain terms, enforce the guidelines. Enforce the guidelines. It's not the time to be soft and to be willy-nilly on them, because if you do, you run into the very distinct possibility that you put yourself in a position where somebody says what I think is the worst of all worlds relative to this. Because if you have a claim that's made against you and you find yourself standing in front of a jury relative to the things that you did, it's one thing to be ignorant of what the guidelines are and just not ever having gotten up off your backside to figure out what the guidelines are. It's a whole nother thing, and I would tell you, in the eyes of most juries, worse to know what the guidelines are and to do nothing to enforce them, because that imputes to you a knowledge and a danger that you did nothing to otherwise avoid. So again, I can't emphasize to you enough how important it is that you get somebody nominated to fill that role, and that somebody, whoever that person is going to be filling that role, takes the steps necessary to see to it that the guidelines are actively enforced. And man, social distancing is one of them. That one goes to the top of the list. We've all seen the discussions back and forth about whether masks work or don't work. What almost everyone seems to agree on is that social distancing pretty much works. So I would make sure that whoever is my workplace coordinator understands the very dramatic nature of seeing to it that otherwise enforced. And when I say enforced, I think you always have to think about policies like this in the event that you have to defend them in front of a jury. One of my favorite things when I talk to people about the necessity of having a policy handbook, for example, or how you handle employment claims, or how you handle disputes at work, is if you have to stand up and defend your business, or if your lawyer has to stand up and defend your business in a circuit court around any of the places where you otherwise operate, how is that decision going to look? How is that policy going to look? So if you have these policies and you're enforcing these policies, then the natural consequence is, how are you enforcing them? Are you handing out verbal warnings? Are you giving written warnings? Are you sending somebody home? What I would tell you that I think the best thing for you to do is have your coordinator who knows what the heck is going on, who is tasked with enforcing the policy. And if you have people that just aren't paying attention to you and just aren't taking it seriously, then you give them a verbal warning the first time, you give them a written warning the second time, and then you send them home for a day the third time. And if they continue to ignore you, I would tell you to send them out of your business altogether. Because if you don't do that, then it looks like you're not really paying attention to the policies and the guidelines. Other things, simple things, and anybody that has been following this knows, but make sure that good hygiene is practiced. Again, being mindful of the fact that you not only want to keep your employees and the public safe, but we have to be in a position to, if we have to defend one of these claims, demonstrate that you had a commitment to the things that we know keep people safe. So practicing good hygiene, keeping, if you can open a window, try to eliminate the possibility of the need for people to touch doorknobs, make sure there's plenty of soap and hand sanitizer all over the office, and have some kind of policy in place, certainly for your motor coaches, where on a regular basis, both before and after use, as well as any fixed workplace you have, that whoever is handling the cleaning is doing a deep clean every so often. We do a deep clean around here at least once a week, and then do a specific hazard-oriented clean in the office every single morning, where every hard surface in the office, all the counters in the bathroom, otherwise wiped down. It's an extra layer of headache, but if you get a claim made against you and you haven't done that, then you are subjecting yourself to potential liability. These are the CDC's top 10 tips to protect an employee's health, and you can read them as easy as I can, but essentially it's things that we've already talked about. Education and training materials, I think, are important. Making sure your employees know what the hazards and risks are. Easy things like sending emails out to your employees, telling them where the CDC website is, encouraging your employees to look at those kind of things, making sure you have thought about what are we going to do if an employee turns up sick at work. What's our program for that? What am I going to do if an employee reports symptoms for me? And what kind of test am I going to employ before they come back? Am I going to use a symptom-based test, or am I going to make them have a actual serology test before they come back? Those are things to think about now and make sure that you have in place. And at the end of the day, the biggest thing I can tell you is what I've already said. Educate yourself on the guidelines and follow the guidelines. Those increase your chances to the greatest extent of keeping your employees helpful and eliminating the possibility for third-party claims. So what you really want to take away from all of it is this. In the negligence world, or the negligence-based world we live in, there are always things that you can do, always additional things that you can do to, quote, make things safer and to make things, quote, better. I do a ton of work also in the freight industry. I represent a ton of trucking companies, commercial freight companies, large, long line carriers, everything from, so I'm fond of saying people that operate 2 trucks up to 25,000 trucks. I represent companies all across the lines there. And I see the different kind of things that companies can do. It's a great example of seeing the different kind of things that employees and companies can do to, quote, make things safer. Collision avoidance devices, certainly the advent of electronic logging, cameras in trucks, all those kind of things. And for the larger carriers where money is no object or less of an object, they do a lot more of those things. So what I always tell people relative to this is anytime you are assessing liability concerns, and whether those are specific to your employees or whether those are specific to third party of the injuries, it really is just educating yourself on what the risks are and figuring out how much risk you are willing to tolerate and how much risk your pocketbook lets you tolerate. You can always spend more money to make things safer, always. I don't know anybody that's ever reached the magic, absolutely safe plateau that we all would like to be at, but you just can't get there, because to get there is to achieve the impossible. It's like adding 1 to infinity every time. You're never going to get the final number. What you've got to decide is how much risk you're willing to live with. And what I would tell you is, as you analyze what it is I've told you and the things that you think about that you might or might not want to do, is figure out, number one, what fits with your pocketbook and how easy is it for you to sleep at night. Because you can certainly always spend more money to make things safer and to try to do things better, and that will give you some additional peace of mind. The bad news in all of that is no matter how much you do, you can't guarantee that you're going to avoid somebody making a claim against you. If you could spend your way out of those kind of problems, then Schneider and Estes and some of those companies would never get sued, because they certainly spend a pile of money every year on safety devices and collision avoidance devices, and they got teams of lawyers and claims department, and they still get sued because things this happen. What you need to decide relative to you is, and the analogy I always use when I talk to folks like this is, anytime you operate a commercial enterprise, it's like you're playing Russian roulette. And the choice that you get in the game is how many bullets you're going to put in the gun. The more you do to try to make your workplace and to make your coaches and to make the places where your passengers board and get off your buses, the fewer bullets go in the gun. Doesn't mean you ultimately don't get your head blown off, but what it does mean is you have increased the chances that you're going to come out of it okay. The less you do, the more you ignore this. That doesn't mean you're going to get sued, because the circumstances just may not line up. But what it does mean is you increase the chances that somebody's going to make a claim against you. And if they do make a claim against you, you very substantially increase the chances that whatever they are able to get a jury to award against you is going to be bad. So that's really what I always try to leave people with as they're assessing what it is that they want to do. There are probably 1,000 questions that you might have on some of this, and I'm happy to answer any questions that anybody has relative to what we are seeing, relative to what you ought to do, or at least think about doing, or the way forward. So if there's anything I can answer for you, please let me know.
I have a question, Pete. My name is Marcus with Evans Tours. I'm in Charlotte. And you were saying that you do check the temperature of the people coming into your office every day. Is that not done by anybody medical or that has a medical background, or is it just you as a person that you appointed to do that test?
Yeah, so that's a really good question, Marcus. And actually, I don't know why it says Pete Schurig under my name, but I'm actually Steve Setliff.
Okay.
He's one of my partners here. We use our firm administrator and her assistants do it every day. And you know, there are some potential for HIPAA implications on some of that, to make sure that that information is not otherwise shared with anybody else. So we have one of these thermometers that simply we have it set, and all it does is tell us green, they're below the temperature, or red, they're over the temperature. If they're over the temperature, they don't come in the office. And we do it every single day with everybody that comes in here. And even in a platform like this, because we got about 30 people that work here, and most of whom, not all of whom, most of whom are fairly educated people. Lawyers can be really stupid like everybody else. And there are a couple that I have to chase around the office before I let them in to make sure they understand. I can't let you in here until I know that you're okay to come in here. But we do it every single day. I can also tell you that I mentioned to you one of our biggest clients around here, in addition to Dominion Energy, is we represent the Omni Hotels and Resorts. They check every employee every day coming in and out of their place of business. Every employee every day before they are allowed in.
So that would mean that on a bus situation, we should check everybody that boards that bus every time they board.
Yeah, so you have a little bit of different situation, because I mean, you can kind of make it part of if they want to ride, this is what they have to do, right? I mean, for an employee, it's a little bit. I don't think there's any gray area. I think it's basically we can stop them at the door and take it. I don't think there's any real HIPAA implications. But for you, if you're selling somebody a ticket, you're essentially saying, these are the conditions and circumstances that I'm going to impose upon you deciding to ride. And one of them is you're going to let me take your temperature. So I would have somebody there who is taking the temperature. That may not be a popular answer. And I'm not suggesting to you that you got to do the airlines, not all, certainly the majority of the major carriers, they aren't doing that, right? They're just relying on people to self-report their symptoms, to wear a mask, and at least some of them to practice some social distancing and kind of letting it go from there. I would suggest that the safest practice is to take temperatures, and that's what I would do, unless it got to be completely unwieldy and unmanageable.
Okay, now that has, excuse me, that has nothing to do with whether you are medically qualified or not, right?
Right.
Okay.
Right.
That answered my question.
Anyone else have a question for Steve?
Yeah, it's Jeff Shanker. Hey, Steve, how are you?
Hey, Jeff.
Hey, I have a couple questions for you on the release. One is if we have a contract with a corporation and a corporation signs a release, though the employees that are actually riding the bus do not, does that protect us in any way?
No, it's better than nothing, but it's not going to get you, in my humble opinion, would not get you out of a circumstance where that particular employee ultimately became sick, because that individual has not signed the release. And anytime you're in that circumstance, and let me go back just a second and talk about releases in general. The real purpose of the release is in those jurisdictions where, and there are some of those jurisdictions in the United States. Alabama is great, for example. If you sign a release in Alabama and to engage in an activity, and somebody walks up behind you and hits you in the head with a baseball bat, you're still, as the person running the business, you're probably still going to get out of it if they've signed the release. It's just a great place that really does a great job enforcing releases. We've been able to defend a multitude of cases for Gold's Gym down there where folks signed a release, did something, signed a release to come on the property and work out, go to the men's locker room, they sit on a bench, and the bench breaks under them. Clearly not within the purview of what the release was articulated to prevent, but a federal court down there will enforce the release and prevent the claim. The states in the mid-Atlantic are not as draconian relative to those releases. So the essence of the release, that is, you're not going to get the reflexive, I'm out of the lawsuit, I'm not going to be responsible for the injuries. So what the release has to do then provide you with some protection is it needs to be executed by the party against whom you want to assert the release, right? So Jeff, you can get on one of my buses and your employer has signed the release or some contractor signed the release, but you haven't, then what's that individual going to say if they get sick or they otherwise get hurt? Well, they're going to say, nobody ever told me about any of the risks that were associated with this activity. And even if the employer says, well, yeah, we did, that individual is going to say, no, you didn't, or I didn't fully understand it, or I didn't fully appreciate it. So it's better than nothing, but I would tell you, I would always want the individual who is the potential claimant to sign the release, because then you've got very clearly the argument set up that that individual was apprised of the risk, that individual knew the risk, that individual of their own volition, and not because an employer sent them there, that employee knew what was going on and voluntarily assumed whatever the risk is. That would give you your greatest degree of protection.
Okay, so two more parts of the question. One is, would they have to sign a release in essence every day, or once they sign a release, is that good for 6 months, 12 months, a year type thing? Okay,
so there's some things I want every day. Okay, and so every day I take temperatures every day. When people come in the office every day, I ask them to certify they have no symptoms, they're not sick, because that changes, right? That's a dynamic situation. So before they come onto the property, I'm wanting a daily representation from them that they're well, they're not sick, temperature's okay, we're good to go. The release itself, once they sign the release, absent a material change in circumstance, ought to be okay. For example, if they sign a release, and then a month after they sign a release, the environment into which you're placing that person changes materially. You've got a motor coach or you've got a shop where you've had a COVID outbreak, right? then there becomes some question in my mind about whether the release they previously signed it would operate to bar a claim. Because at the time they signed the release, presumably you made them aware of all the pertinent circumstances. We think we have a pretty good environment. We think it's clean. We haven't had any real substantial outbreak. We're doing the things that we need to do. There are still some risks because people can be asymptomatic and you can't kill every virus everywhere. So you signed the release knowledgeable of those risks. If something changes, however, right, if you're putting them in an environment where you've had a cluster or you've had an outbreak and they didn't know about that or that changed from the time they signed the initial release, then I'd say you better get another release from them where they are fully apprised of the risk. Because otherwise they'll say, well, wait a minute, he never told me about this, right? It would be like if somebody signed a release to go skydiving and instead of skydiving, you change the activity on them completely and instead they were bungee jumping, right? Then the release wouldn't otherwise apply.
Okay. And the one last question on the release is we're well aware we have a couple weather events hitting the Gulf Coast this week. There's potential for hundreds, if not thousands, of motor coaches to be requested down into the Gulf to help to move people due to the emergency. Under an emergency situation, evacuation type, would release be warranted, needed, recommended?
Would that request typically come from FEMA?
Yes, and around, yes. Or
yes, I would check. I would be surprised, but the stuff surprises me every day. I would be surprised if there's not some specific authorization in the FEMA procurement process that doesn't provide you with some degree of immunity in that circumstance. That's what I would anticipate seeing. So that's what I would look for. Absent any statutorily provided immunity based on the procurement by FEMA, then I'm still looking for a release in those circumstances, because absent that, you still could have potential liability concerns. But step one, and everything in me intuitively suggests that if FEMA is going to procure your services as an operator to help in an emergency evacuation circumstance, that you're going to have some immunity granted to you in the procurement process. That's what I would check first.
All right, thank you.
Yes, sir.
Anyone else for Stephen? Well, you did a great job, Stephen.
Well, thanks for having us. Linda, if there's anything anybody else has any questions about, please let us know. And Linda, I guess I'll get on Cindy for this. We ought to have our email address up here somewhere. That's okay. But if anybody has any questions, anything that you got because sometimes we do these things and people are more comfortable asking questions offline for whatever reason, you should feel free to give me a call. Phone number's listed there. I'm glad to talk to anybody in the association about anything that I can help with. I know this is a god-awful time for everybody. I do believe we're going to get on the other side of it, and I want to make sure that to the extent I can help you get on the other side of it with your business intact, that I'm there for you. So please don't hesitate to call.
Thank you,
Linda, can we get a copy of the PowerPoint to have access to the sample of the liability waiver?
I'm sorry, I can't. I'm sorry, ma'am, I can't hear you.
Stephen, they want to know if they can have a copy of this PowerPoint.
Sure, Linda, I can either send it to them or you can disseminate it as you see fit.
Cindy did send it to me, so if it's okay, I will send it right out to them.
Sure, absolutely.
Okay.
Okay, thank you all for having me, and Linda, I'll see you later this week.
Yes, another one coming up Wednesday. Thank you so much.
Thanks, guys.
Do this, Stephen. I know it's valuable time for you, and we do appreciate it.
Yeah, I'm glad to do it. It's one of those things, again, people have questions right now about what they should do. And it's when it takes a team of lawyers at a law firm 2 or 3 days to figure out what we should be doing, then I know the kind of questions everybody else has. So I'm glad we can help.
Thank you.
Yes, ma'am.